Yeah.
Welcome to Expert Views on ADR Ever, a podcast about simplifying alternative dispute resolution in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike-Umegbolu, postdoctoral fellow at the University of Brighton, United Kingdom. And I'm delighted to welcome Professor Paul Idornigie. He is a professor of commercial law at Veritas University, Abuja, Nigeria. Prof is a chartered secretary and a chartered arbitrator, UK, a notary public for Nigeria, and an author. He is a senior advocate of Nigeria, SAN. SAN is a title that may be conferred on legal practitioners in Nigeria of not less than 10 years of standing and who have distinguished themselves in the legal profession. It is the equivalent of the rank of Queen's Counsel in the United Kingdom. Prof was also a senior lecturer at the Nigerian Law School Abuja. He was involved in the setting up of the Abuja and Asaba Multidoor Courthouses, a former member of the National Executive Committee, NEC, of the Nigerian Bar Association, and was former chairman, Chartered Institute of Arbitrators, UK, Abuja Chapter. Prof wears too many hats, so I've left the link to his profile below. Thank you so very much, Prof, for coming on the show. Let me stop sharing now. Thank you so very much, Prof. Can you hear me?
Yeah, I can hear you. Thank you, Chinwe. Yeah, thank you for having me. Yeah.
Oh, I'm so grateful for you honoring the invitation. So without further ado, question one is, how far has ADR been able to enhance access to justice in Nigeria?
Well, thank you very much. I think before answering that question directly, we have to address the issue of what ADR really means. Because ADR means several things to several people because of its jurisprudential and conceptual challenges. First, what does the acronym stand for? Second, if the A stands for alternative, the next question is alternative to what? Third, does the acronym include arbitration? And lastly, what are the contours of ADR? For our purpose, we can state that at the core of ADR processes is mediation, a non-binding process. If you look at the National Industrial Court of Nigeria has ADR rules, and they define ADR to include mediation and conciliation. But for some purpose, arbitration is included when ADR is seen as alternative to litigation. No word are there that you hear of arbitration and ADR conferences. Now, to your question, the application of ADR processes and mechanisms has advanced the effectiveness of administration of justice in Nigeria. The corollary has been that there is now greater access to justice. This is demonstrable by the establishment of multi-door courthouses in several cities of Nigeria, providing several doors. They have doors for arbitration, mediation, conciliation, early neutral evaluation, MEDAP, and all that. And so you also find in Nigeria that almost all the high court civil procedural rules, they provide for ADR. And as a lawyer, you know we have the rules of professional conduct in the legal profession, 2007. The rules recognize ADR for use by lawyers before resorting to litigation. And we now have the National Industrial Court of Nigeria. The primary purpose of that court is to take care of trade disputes between employers and employees, workers and workers, trade unions and workers, and trade unions and trade unions. Now, if you recall, there was the third alteration to the Constitution in 2010, And that constitution vests exclusive jurisdiction on industrial matters on the National Industrial Court. And the constitution also mandated the National Industrial Court to establish an ADR center. So if you go to the National Industrial Court of Nigeria today, you find the ADR center. And I find, because I've been there, I find what the center does relevant to our conversation this morning, because the mandate includes labor, employment, trade unions, industrial relations, matters arising from workplace, the conditions of service, including health, safety, welfare, employee, worker, and matters incidental thereto. We also have a new bill in the National Assembly now called Arbitration and Mediation Bill. When this bill is passed into law, mediation will be formalized in Nigeria. So I think that ADR has come to stay in Nigeria, and the scope is being widened every day. Thank you.
Thank you so very much, Prof. You know, I was about asking about the National Industrial Court, because I realized that that should have been the first question, but I'm so glad that you touched on that. And yeah,
okay.
Thank you so very much. So is there any measurable difference or impact on the cost and time frame for settling disputes under ADR compared to litigation?
There's a remarkable difference with regards to cost and time frame for settling dispute via ADR as compared to litigation. ADR is generally cheaper apart from arbitration. Again, like I said, there's controversy as to whether arbitration is part of ADR.
Yes.
But if you include arbitration as part of the process, arbitration is expensive. But the core ADR processes, like I said, like mediation, is cheaper than going to court. Now, with regards to the time frame for resolving workplace disputes, through sometimes it takes an hour or 48 hours to resolve such disputes. And if they cannot be resolved within that short period, you may have to resort to other processes. So really, it's faster, cheaper than litigation. Thank you.
Okay, thank you. So are employees or workers aware of ADR options regarding disputes or conflict that might arise at the workplace in Nigeria?
I think they are, because with the third alteration to the Constitution of 2010, now the issue of ADR is not really constitutional, it's also statutory. Like I said earlier, we now have an ADR center at the National Industrial Court. Secondly, the Trade Disputes Act of 1976, the National Industrial Court Act of 2006, they all expressly provide for ADR in industrial and labor sector. Now, we do not have statistics to demonstrate the level of awareness of ADR, ADR options regarding dispute or conflict that may arise. But it's important to say that organizations increasingly, in fact, those of us who do more arbitration, we're in trouble, because increasingly, when they are drafting contract, they prefer clauses on mediation than arbitration. And most organizations now, I try to ensure that internally they have procedures for resolving conflicts by using mediation and not arbitration. So I think that increasingly mediation is taking center stage in Nigeria.
All right, thank you so very much. So to what extent are employees encouraged to use ADR to settle discrimination, bullying, and harassment in the workplace?
Now, disputes bordering on discrimination, bullying, and harassment in the workplace are not amenable to the use of ADR to resolve them. Bullying and harassment are issues that ought to be resolved in most cases via disciplinary action. In some cases, they may border on crime. And if crime is established, they should be dealt with accordingly. Now, in the area of discrimination, this can arise in many ways, either as a result of disability, race, sex, age, national origin or state of origin, color, or religion. Now, such complaints should be addressed properly. And complaints about discrimination should be handled at managerial level. It should not be left to the parties to handle by themselves. Thank you.
Okay, so why is ADR more prevalent or popular in the more complex societies than it is in the less complex society? Nigeria is a given example for the next one.
Before I answer this, I'll tell you one story from a friend.
Okay.
I have a friend who says he does not like watching movies. And I said, why? He said, because he feels that he's better than the actors. He just decided before him. That is what happened in Nigeria. UK is well developed in terms of industrial relations. Yeah. We have the advisory, conciliation, and arbitration service. We don't have any similar body. Their use of mediation is highly formalized, but we are not that formalized in Nigeria. But that is not to say that we do not practice mediation in Nigeria. It's just that it's the formal process. Now, as we speak, if you go to our villages, you see our obas, our emirs, our chiefs presiding, mediating. So mediation is not something new to us. As a lawyer, you recall West African Court of Appeal. As far back as 1932, there's a reported case of Asaba and Amoaku where customary arbitration was recognized. As recently as 2020, the Nigerian Court of Appeal, in the case of Atama and Ugwagu, also recognized customary arbitration. So what we are saying is customary arbitration or mediation is not alien to native jurisprudence. It's just that it has not been formalized. That's why we are praying that if the new bill is signed into law, they will not have a legal framework for mediation in Nigeria. But as we speak, it is practiced in our villages. It's been with us. It's not Western. I call it Afrocentric. It's not Western. It has its origin in Africa. Thank you.
Yeah, I quite agree with you on that. Thank you so very much. So what is the way forward for mass advocacy or awareness of the benefits of utilizing ADR in settling disputes or conflicts in the workplace?
Now, I refer to the Trade Disputes Act of 1976. Under that act, there's provision for industrial arbitration panel. Then under the National Industrial Court Act, I referred to a center, the ADR Center. I talk about the multi-door courthouses. I talk about the high courts. All these are institutions that now promote. So my advice is increasingly, these bodies to refer litigants to use. Look at the multi-door courthouse. They're the one in Lagos. It's very, very effective. In fact, it has a mediation yearly where they handle all kinds of disputes. So today, there's hardly a state where there's no multi-door courthouse. So for me, the awareness, so people should leverage on this ADR to resolve workplace dispute. And unions should be encouraged to resort to a cocktail. I tell lawyers, when a client comes to you, you should tell him all the options available. In other words, you have a toolkit where there's a door for litigation, there's a door for arbitration, there's a door for mediation, there's a door for early neutral. So there should be doors for all the ADR processes, so that it is not just litigation that is the door available to lawyers. I tell lawyers that litigation should be the last door when a client comes to their office. Arbitration and other ADR processes should be the first. So we encourage, I get involved in training, paper presentations. We are encouraging organizations to have a protocol on the use of ADR processes.
Oh, Thank you so much, Prof. But I heard that when the lawyers were, when I conducted my research, they talked about not being recognized when you settle cases via ADR. You know, when you're considering, when they're considering the rank of SAN. Is that true?
That's not correct.
Okay.
That's not correct. There's a column for ADR cases. In fact, some lawyers who have appeared before me, who are applied to take silk, they came to me to give them references to confirm that they have appeared before me. That's not correct. Even for judges, because the judges are scored based on judgment delivered. So courts also take into account arbitral award and settlement. It's not correct. Not correct. The form for SAN, I'm taking silk. The form for SAN has a column for ADR matters.
ADR matters. Okay, thank you so very much. So can conflict or disputes at the workplace be prevented or avoided?
In a workplace, there will always be complaints. There will always be disagreements. There will always be problems that require our attention. Now, conflicts and disputes in a workplace cannot be prevented or avoided. They are inevitable. However, they can be managed. You know, unless you are in a Robinson Crusoe type of island where you are alone, that is where you will never have conflict.
Yes.
So once two people gather, there will be conflict, and the two people must find a way of resolving it. Thank you.
Okay. So what type of mediation is best suited for workplace conflicts and disputes?
Now, workplace conflict is also referred to as organizational conflict. Now, and it's described as the state of disagreement or misunderstanding by individuals or groups within the organization resulting from opposing needs, ideas, beliefs, values, and goals. Now, I always advocate two types of workplace mediation. The first one is what we call self-mediation. This is a situation where the mediator wears two hats, that of a party in a dispute and the other as a mediator. The second one is a managerial mediation, where a superior officer plays the role of a third-party neutral that facilitates negotiations between his subordinates. So I recommend mediation at those two levels.
Okay. Okay.
Both self-mediation and managerial mediation.
Managerial. Okay. Okay. So, what are the benefits of using mediation to settle workplace and conflict, and the disadvantages as well?
Okay, let's start with the benefits.
Benefits. Okay.
As a dispute resolution process, it focuses on helping the parties to a dispute to plan for their future relationship. Now, one thing about mediation is it does not focus on who is right or who is wrong, and does not apportion blame. We always say that you cannot come out of a court smiling, but in mediation, you can come out smiling. Now, you use mediation to build confidence in a workplace. The focus on the needs and the interests of the parties rather than their legal rights changes the way that disputes are categorized, analyzed, and processed. So it's a way of ensuring that relationships are maintained, unlike when you opt for litigation where relationships are strained sometimes forever.
Yeah.
Then talk about disadvantages. Now, there are really no apparent disadvantages to use mediation in the resolution of workplace conflicts. But we cannot use, like we said earlier, we cannot use mediation on issues of indiscipline, misconduct, and it cannot serve as punishment for behavior we regard as unacceptable. So those are things we think they should reserve for the normal court process or the normal procedure for discipline in the office. An office should have discipline procedure. If you do this, this is the punishment. If you do this, this is the punishment. Thank you.
Okay. So how about the disadvantages?
That I'm saying, it does not have disadvantage.
It doesn't have.
It's just that it cannot, like I said, it cannot be used for indiscipline. If there's misconduct, you should be punished within the rules. So the rules should determine how to punish you for misconduct or bad behavior in office.
Okay.
And like we said earlier, it cannot be used for bullying or sexual harassment or intimidation. It cannot.
Okay. Yeah. Okay. So some scholars have argued about conciliation and mediation being the same. What is your view on that? Do you think they are the same or they are different?
Well, I am guided by the ancestral model law, by the ancestral model law on mediation. If we go back, in 2002, there was ancestral model law on conciliation. And in that model law, conciliation was defined to include mediation. In 2018, we now have ancestral model law on mediation. In the 2018 version, mediation is defined to include conciliation. So as far as ancestral is concerned, there's no difference between conciliation and mediation, in the sense that the two processes, they get a neutral third party to assist them to resolve their dispute. But if you look at ICSID has rules for conciliation, and lately, ICSID has got rules for mediation, and ICSID decided to draw a line between conciliation and mediation. Again, one clear line there is that ICSID it applies to parties to the convention. So it's the parties to the convention that are bound by conciliation, but mediation can be used by anybody. Then in Nigeria, we have the Institute of Chartered Conciliation and Mediation. As far as I'm concerned, the way I look at disputes is, if you go to court, the court will pass a judgment. If you go for arbitration, the arbitration tribunal will give an award. But if you go to mediation or you go to conciliation, a mediator or a conciliator decides nothing and awards nothing. So for me, I cannot see it. Okay, so we argue, one is evaluative, the other one is facilitative. For me, it's a process where a third party assists the parties to solve their problem. So insofar as the mediator cannot decide anything, award anything, I don't see any difference between mediation and conciliation. But my friends who are members of ICFC in Nigeria will not agree with me, but my position, like I said, I am guided by ancestral.
Yeah.
As far as ancestral, mediation includes conciliation, conciliation includes mediation.
They can be used interchangeably. Okay, yeah.
That's one.
Okay, so the final question is, what is your advice for people pursuing a career in ADR?
My advice is that first, they should be open-minded and they should have a broad perspective on how to resolve dispute. Like I said earlier, they should themselves like a general who should know when to go to war or when not to go to war. I said earlier, as a lawyer, litigation should be your last choice. It should not be your first choice. So what I urge lawyers to do is have a toolkit. That's why I like the concept of the multi-door courthouse.
Yeah.
Know which door to pass. Know when. See, as a lawyer, you should be able to establish a nexus between a dispute and a process. A nexus between a dispute and a process. And say, generally, for instance, for post-election matters, I have to go to court. If it's a pure commercial dispute, I'll go for arbitration. If it's a matrimonial cause, I'll go to court.
Yeah.
In other words, you should know which tool, by which I mean litigation, arbitration, mediation, which tool to deploy at any particular time.
Okay.
And for me, that is what training as a lawyer should entail. You should know what to deploy at a material time. Don't have this one size fits all for litigation.
We're running out of time.
Once,
yeah.
Okay.
So
I will just
summarize it.
That I say that. Okay, let me summarize that.
Good.
What we are talking about here now is also comparable in the holy books. Both the Bible and the Quran, they provide for ADR. Now, in the Bible, look at Genesis chapter 18, verses 23 to 33, the city of Sodom and Gomorrah. Abraham was a mediator. And if you go to the Beatitudes, Matthew chapter 5:9, blessed is he who is a peacemaker. And Matthew chapter 18:15-7, the sinning brother, that if your brother hurts you, if you look at that Matthew 18:15-17 deals with ADR. And the Quran too, that when two people are fighting, they should be encouraged to reconcile and settle. What I'm saying, ADR also has the backing of the holy books. Thank you very much.
Oh, thank you so very much, Prof. We don't have much time, but thank you so very much for demystifying the intricacies of ADR workplace and conflict in Nigeria. I appreciate your insights, and I'm so grateful that you agreed to come on this show despite your busy schedules. And to my listeners, thank you so much for your constant support. Stay tuned next week for more episodes on ADR and workplace conflicts in Nigerian perspective. Thank you very much, Prof. Bye-bye. Bye. I'm ending now.
My pleasure. Nice having you.
Bye.